So it's our time to start. Welcome everyone to the Women Advancing Privacy event. We are here today with these 5 remarkable women who are going to tell us a bit about their privacy journey and interesting topics, different perspectives about privacy, which are related to their own to what they're experiencing in their privacy professions and privacy journey. It's a LinkedIn Live, so a brief privacy comment. It's going to be recorded. Everything in the chat and in the camera is recorded and it will be available later for whoever wants to watch. So be mindful with your privacy. Welcome to everyone who is here live and who is watching later. I'm Luiza Jarovsky. I'm the creator of the Privacy Whisper newsletter. Also, I'm the founder and CEO of Implement Privacy, a privacy academy focused on advanced privacy courses. I'm originally Brazilian. I'm a lawyer. I went to the University of São Paulo. I'm also doing my PhD in privacy. And today we are going to discuss privacy with these amazing women. And I want to start with some brief comments about what I think are important challenges that are being experienced by privacy professionals at this point in time. So I see 2 main challenges. One is regarding speed. So if we see in the last months, there have been so many legal advancements and fines and regulatory advancements. And I see any privacy professional anywhere in the world, it's difficult to keep up with everything that's coming on. And a few examples. So in Europe, we have some upcoming legislations, Data Act, Data Governance Act, Digital Markets Act, Digital Services Act, AI Act. Everything in a short period of time. So, and we are, as privacy professionals, we have to be knowledgeable on all those new laws. All of them have privacy and data protection aspects. So it's challenging for all of us working in this field. In the other side of the Atlantic, there is in the US, every state now wants to have some privacy presence. So we have California, Colorado, Virginia, Connecticut, Utah. These are the ones already in advanced state, and various other states with bills in advanced legislative process, and all this now privacy has this characteristic of global influence. So we saw with the GDPR and now the CCPA. So everything that comes new, you cannot ignore just because you don't live in that country. So it has an influence on you. So this is challenging. It's a very specific challenge. I don't think any other professional in other fields have this global challenge of having to be updated all the time. So this, I think every one of us is experiencing it. So I wanted to bring to our talk. The second challenge that I see happening, and it's related to my PhD and related to what I write in the Privacy Whisper, related to also to implement privacy, is the interdisciplinary character of privacy. So many of us are lawyers, right? We came from law school, and at least from my experience, I went to law school in São Paulo, the University of São Paulo. And lawyers, we tend to be very focused in the law, right? So we learn the law and we like to discuss legal topics and we have our legal jargon. And we are not trained to always look for other disciplines. And privacy is different. So I will also give some examples. So privacy and UX. So one of the topics of my PhD are dark patterns, and Mahi is going to talk about this today also. If you are dealing with privacy UX, you have to think about cookie banners, design, transparency, user-centric perspective. So privacy is not only about having a privacy policy, it's about having a design that is compliant. And at the same time, it's not clear exactly what this design should look like. So it's a very interesting challenge, and it's real. We see fines coming on. So there was the Epic Games FTC fine. It was $520 million for dark patterns, for design. So you cannot ignore, you cannot say that's not legal. It is real. And not only the FTC, there was the Discord fine. It was much less in terms of money, 800,000 euros, but also meaningful in terms of it's being regulated, and then there are more fines are coming up. So another example, this is one interesting area of interdisciplinary in privacy. A second example is privacy and marketing that Siobhan is going to speak about today. You're going to listen to her. It's a fascinating field and also very technical. So as a privacy professional, you have to understand Google Analytics. When analytics is good, when it's not good. Data clean rooms, are they compliant? Are they not compliant? Your client is going to ask, oh, is this API enough? Is it good? So you cannot just look at the law, and the answer will not be in the law. You have to go further as a privacy professional. So this is very interesting and very intellectually challenging. I think it's such a nice place to be in, like having this opportunity to learn more about other fields. And lastly, we cannot have a webinar or an event without talking about AI. So AI is the third interdisciplinary topic. It's new, and 2 months for the last 2 months that all we hear about is AI, and it's still uncertain, right? How will AI governance work? Will it be with us, privacy professionals? Will there be a separate field, a separate department in companies? We still don't know how it's going to work in practice. But we know, and I write a lot about that at the Privacy Whisper, there are privacy challenges involved in AI. So there are reputational harms, privacy breaches, problems with consent. There are various privacy challenges just involved in AI applications, not only large language models, but other AI applications. And we as privacy professionals, we are expected to be into the hype, not only the superficial hype, we are expected to know what's going on. So it's super interesting what's going on, and those are it's interesting, but it's also challenging. It's a lot of pressure on us privacy professionals, and also thinking about those challenges. The speed, right? The regulatory changes, and also the interdisciplinary character. That's where I came with the idea to start Implement Privacy, which is the company that I started recently, and we are offering advanced privacy courses for privacy professionals, exactly with this goal of helping professionals understand these topics. They are not concentrated anywhere. You cannot find easily, and we need the guidance. We need the structure to understand them and to navigate. So if you're interested, our next courses are about privacy enhanced design and privacy and AI. Lastly, I want to finish this introduction. Also, for those who want to pursue a master's or PhD in privacy, I'm finishing, hopefully almost finishing my PhD in privacy and fairness. And also, I think it's a very interesting area if you have any academic ambitions or if you want to go deeper in a topic. Just to give an example, my PhD is about privacy and fairness, and I analyze a few unfair practices during the data cycle that I believe in research that are not being properly regulated. So I'm proposing a regulatory framework for fairness in data protection. So if you have these academic ambitions, if you want to discuss, feel free to connect on LinkedIn if you want to talk about a PhD or ideas. I'm passionate about it, and I think it's fascinating, also a great way to grow in the career. So now let's go to our amazing speakers today. You'll see, it's really, grab your coffee, your water. I have my special privacy mug here. And each one of the women today are going to speak about different aspects of privacy, and we are starting with Merry.
Hi, everyone. It is so great to see how many people are tuning in from all over the world. Special shout out to my friends in here and friends I have yet to make. Thank you so much for joining us. If you search me on LinkedIn, you'll notice that my tagline says Merry Marwig, overly excited about data privacy tech. And that is an extremely dorky thing to say, but it's true. I've spent the last 3.5 years researching the data security and data privacy tech markets at my former role at G2.com. So that's everything from data privacy management solutions to consent management platforms to data-centric security tools, you name it. I personally created all of the data privacy software categories on G2, so I've had a front row seat watching this market grow, and I totally love it. In the last few months, I did switch to the vendor side of things. So now I'm working at data privacy software provider Datagrail.io. And at my job at Datagrail, I have the opportunity to help companies put their privacy programs in practice at the scale required to do right by individual people, so their customers and employees. And I got into the data privacy world not because I love tech so much, but because I know firsthand what it's like to be a victim of privacy harms. And that's everything from financial harms from identity theft, which almost led me to lose my driver's license due to some extremely ill-constructed laws in the state of Illinois, to emotional harms and the threats of physical harm due to targeted stalking by a person using commercial and government surveillance sources. I was also part of the 2015 US Office of Personnel Management hack, where all of the personnel data of every single US federal employee was stolen by Chinese hackers. So I personally don't feel very comfortable traveling there now, even though I really would love to. But this has been scary. These privacy harms have fundamentally changed my life, who I've become, and now also my career. And for many years, there was like zero dialogue on privacy harms, and we didn't even have common words for this. But now in the last handful of years, we're having the discussion of privacy rights in society, which is something, of course, I welcome. But I also want our professional discussions to include privacy harms. So I recently earned my CIPM. Shout out to the IAPP for an excellent course. This book was really great to read. But one thing that struck me about this certification was the very last chapter of this textbook talks about how privacy teams should handle a data breach incident. And when I was reading that, I was like, why is this the last chapter? That's just the beginning, right? Especially for those of us who work with consumer brands, you have to put your customer's experience front and center. So what is your customer's experience going to be from that privacy incident? And will it lead to a privacy harm? And that's what I'd really like to focus our talk on today, how our work impacts individual people, because that's what this is all about, people. This is not about ticking compliance checklist boxes. Our work is about reducing privacy risk, reducing harms from the products and the services that we represent, and in turn, also reducing business risks to our companies. So it's a win-win. So what are some of those harms? Daniel Solov and Danielle Citron wrote a very thorough paper on privacy harms, which include physical harms, like I discussed, economic harms, reputational harms, psychological harms like emotional distress, autonomy harms, like being manipulated or lacking control or having a chilling effect on your actions, discrimination harms, and relationship harms. But what is an example of that? So we've all heard of the Sephora case, right? Is it a sale? Is it a share? But have we really talked about the underlying issue here? A sale or share of what? What are we talking about? What is the potential for harm? So let's talk about that. The California Attorney General said that Sephora allegedly shared with third parties the location data of women, customers, and information about those people's online shopping cart contents, which could include products like prenatal vitamins that they saw on their website. That might seem like innocuous data at first, but it's not. That's dangerous data, especially for people who are living in states where their reproductive lives are under surveillance. So as many of you now know, in Texas, it's illegal to perform an abortion, and it's punishable by up to life in prison. What's interesting about their laws there is that the enforcement of those laws is not done by government, but rather by private citizens. So a private citizen can basically bounty hunt someone because of the way the law incentivizes people with a bounty if they succeed in suing someone who helps get an abortion for someone. And people can use commercial data about specific women to do just that. That could be internet search histories, information about apps that track reproductive health data, or commercial information like someone's shopping cart, like did they purchase a prenatal vitamin? So imagine somebody does make a purchase like that, and now that data is out there, but that person might have had a miscarriage, which is very common, and there's obviously no baby born. Is some bounty hunter going to go and then claim that the person who purchased prenatal vitamins possibly had an abortion, and now they have to go prove that they didn't? That scenario is extremely disturbing to me, and I hope it's disturbing to you as well. And so my question is, how does this relate to data privacy tech? Okay, my big takeaway for anyone watching today is to do what the California Attorney General said to do, which is to make sure that your website provides proper opt-out links and honors global privacy control settings, so that when a visitor comes to your site and doesn't want their information sold or shared to third parties, that your company honors that and does not create a serious privacy harm for someone. I actually recently read a survey by Corey Underwood, who was a recent guest on Siobhan's podcast, who you'll hear from later. showing that 93% of the websites that he visited did not properly detect global privacy control signals. Folks, this needs to be done. So if you have one takeaway from my session today, please work on that. If you do need help with that, you feel free to shoot me a message and I can send you a step-by-step how-to guide written by my colleagues, Alex, Ignacio, and Mark, or I can drop that into the chat after here, or you can simply go to globalprivacycontrol.org to learn more about that. The second privacy harm that I want to talk about today is related to the fair information practice principle of data quality and integrity. This is where companies use personal data that is accurate, relevant, timely, and complete as reasonably necessary to ensure fairness to an individual. So what's a privacy harm related to that? I'm going to introduce a potentially new phrase to you called algorithmic exclusion. I'd like to give a shout out to Heidi Sass for sharing MIT professor Catherine Tucker's work on this with me. What is algorithmic exclusion? It's different from algorithmic bias, which you've probably heard of. That is decisioning based on bad data sets that have discriminatory actions baked into the training data, so then the outcomes are also discriminatory. Algorithmic exclusion is different. This is about making either wrong predictions or no predictions about a person because of lacking or fragmented data. And that consequently discriminates or excludes someone from some kind of a benefit. So this matters because whether or not you realize it, we live in a scored society. We all have our regular credit scores, and then we have our secret credit scores from data brokers, some of whom have over 16,000 different data points about various individuals. For example, data brokers likely know what coffee you ordered through an app and when. They'll know what online purchases you've purchased and then returned. They'll read the reviews that you leave on Airbnb or Yelp, and many of them also have data about how many times you've opened your LinkedIn app today. Oftentimes, companies use this data broker information to do fraud checks, housing verification checks, employment checks, or personal risk assessments. But what if a consumer doesn't generate enough data for these brokers to make accurate decisions about you? What if the profiles they have on you are incomplete? So for example, many companies use email address and phone numbers as key identifiers, and that can be problematic. Why? Because which people are more likely to change their name and thus their email? Women, usually after a marriage or a divorce. Who is more likely to switch phone numbers and potentially get a recycled phone number? Poorer people. So I hope you can imagine how that could lead to fragmented data, that could lead to incomplete profiles, and then poor decision-making about someone. So what's the takeaway here? I want folks to understand their risk when it comes to automated decision-making. As Luiza mentioned earlier, this is a hot topic right now, so please consider algorithmic exclusion when you're doing your risk assessments. It's about not just what data you are processing, but what inputs are possibly missing. If you do need help with risk assessments, this is something that we do at the company I work at. Feel free to reach out. Additionally, if you want to do some of your own further learning on this, I recommend you keep an eye out for the proposed Artificial Intelligence Act in the European Union, forthcoming regulations by the California Privacy Protection Agency as it relates to automated decision-making in California. And lastly, the National Institute of Standards and Technology just released an AI risk management framework playbook this past month. So feel free to check that out. I am running out of time, so I'm just going to wrap this up and leave you with a couple recommendations. If you want to learn more about privacy harms, I highly suggest following Daniel Solov and Daniel Citron's work about this. Danielle Citron wrote a book, which I highly recommend, called The Fight for Privacy, Protecting Dignity, Identity, and Love in the Digital Age. I want to give a shout out to my friend Sorbel for recommending that book to me. This author is also going to be speaking at the upcoming IAPP event in Washington, D.C. this April. So do check her out. And I just want to say thank you to Luiza and our fellow panelists for today for sharing their knowledge. I'd like to thank all of the people who are tuning in. When I first started my career in data privacy, I was mostly alone all the time. So I really found a lot. I got a lot out of the networking that I did on LinkedIn. And so thank you to everybody who's helped me grow and develop in my career. If I can do that for you, if there's any question you have, or you simply just want to connect, please feel free to find me on LinkedIn. and I'd be happy to continue the discussion afterward. So to wrap it up, thank you to everyone in this field for your work. Your work in privacy matters. Your work preventing privacy harms matters, and that matters to people just like me. So thank you. Sending it right back to you, Luiza.
Thank you, Mary. So now we have Jessica. Please, yeah, if you could, everybody, please start introducing yourself.
Sure. Hi, everyone, and thanks for joining. Jessica Lee, based in New York, a partner and a chair of the privacy practice group at Loeb & Loeb, which is a U.S. law firm. And I'm going to talk a little bit about the privacy journey, right? The getting into the privacy space from a career perspective. And for me, when I was in law school, and I think this is starting to change, but not completely. There was no privacy in law school. Like there was no class. There was like media and communications, but that was more about the pipes through which data gets sent, not the data itself. And so when I left law school, I wasn't even aware that this was an area I could practice in. And I started my career in litigation at Skadden Arps doing securities litigation, and made my way several years later after a clerkship and some other time over to Loeb into their litigation practice. And once I was here, I realized they had this other group that no one had told me about called Advanced Media and Technology. And that was a group that they formed when Google acquired DoubleClick with an eye to addressing all of the potential issues that would happen when advertising went online. And that's sort of where all emerging tech, how it started, but kind of all emerging tech fell into that group. And of course, privacy issues came up. So they would come to me to do research. And after about a year into my time at Loeb, I said, well, forget litigation. I'm going to leave that behind. And I moved over into this practice group where I, then began to really focus on technology and the intersection of privacy and technology. So from the, outside counsel perspective, I think you'll generally find most privacy practices have 4 key buckets of things that they do and need to know how to do. The first is really building up privacy programs, right? Clients will call this doesn't happen as much as it did over the past couple of years because the, landscape is shifting, but, clients might call and say, we have no privacy program. We need you to help us stand something up because either there's a new law or a company that was smaller is hiring their first general counsel or first inside lawyer. And now this is a priority, or it's a company that has something in place and needs to adjust and make shifts to deal with the changing legal landscape, right? So it's trying to get in and figure out, what does a program look like? And, I like to, if a company is willing, at least start from a philosophical perspective, like who do you want to be, right, as a company, right? What do you want to be very privacy forward? Do you want to be aggressive? What is your stance? What are your priorities? How does privacy fit into your business strategy? And then build from there. Because as Luiza mentioned, the laws are changing, and what we do today is not going to be what we do tomorrow, right? Like the program we set up right now is not going to be the same a couple of years from now because there'll be a different set of laws. There'll be new technology on all sides. Technology we're using for business purposes, technology we're using for privacy purposes. Things are just going to change. So I think there was a point where a company would say, well, we just need to get this done and we'll check the box and we'll be done with privacy and we can move on. But privacy is not a thing that you're ever done with. It's just a journey that's going to continue to evolve. So I think the best thing to do is to try to set up a program that can be flexible so that you can look through like your company lens when a new law comes on board and say, this is how we've set things up and this is how we're going to handle this, as opposed to trying to rebuild every single time. So, part of the role as outside counsel is to really understand your client's business and their priorities, the technology they use, the data that they have access to, so you can help advise on what that program looks like. The next kind of big bucket of things you might be asked to do is really about product counsel, right? Companies are launching new things every day. Sometimes these are actual things, items, connected devices, connected cars, fill in the blank, or it's a new tool, it's an app, it's a website, it's something that's involving data. And they need to, in the ideal world, and I know this is true in-house as well, it's like the earlier you come, the better. But outside counsel tends to be the last call. So it's, hopefully it gets to inside counsel first, and then inside counsel gets to outside counsel. But the earlier you can get in, the more of a voice you can have. And not that you can't do this, but how do you structure this in a way that's going to work and be flexible for the requirements that we have, and also so that you don't come at the last minute and have to get a no, which is, I think for most of us, the thing we try to avoid. It's not no, it's how do we make this work for you. And then the last two kind of buckets of things for legal counsel, obviously transactional matters, making sure you have, buttoned up contractual agreements in terms of protecting your data, particularly when you're sending it out to third parties. And then, being ready on the security front, right? Understanding what you need to have from a proactive perspective, but then when there is a breach, because there will be a breach for most companies, it's unavoidable, what to deal with on the back end. So those are kind of the four pillars for, structuring a privacy program for outside counsel. And, for me, coming from doing securities law for a while, doing intellectual property, and then jumping into the space, it really required, I told someone, how did you get up to speed? I said, at one point I was just sitting in the privacy laws. Like I'd printed out all of the, what was the working party now, the EDPB guidance on the previous directive leading up to GDPR. And I just had all of this paper sitting around me. But I mean, I've moved to digital, which I highly recommend because it helps you keep your stuff with you. But, this is a space where, like we said, the law is ever evolving and you really need to stay on top of it. And you need context, right? Like there are laws, like the CPPA that Merry mentioned, will start their enforcement of the CPRA and the CCPA in July. So we have no idea what they're going to do. We have a sense because we know some of the people who are part of that agency and what their priorities are, but we don't have like a lot of, enforcement action or case law to look at. So you have to put things in context and what has been done before, what have previous courts done, what have other states done, what has the federal government done, and that will help inform where this might go. So a lot of it requires, the historical context for these laws, and then also paying attention to what's being done today. But for younger lawyers, I say this is a great area to be in, and I encourage, because I'm not going to have 20 years of experience in certain laws over you. Like I tell the associates we work with, like we're reading these laws at the same time, right? I have just as many years of experience in Virginia privacy law as you do, in Illinois biometric laws, for the most part as you do. So I might have more context and a different perspective, but I think it's a real opportunity to come in and make yourself an expert. And I think critical to providing advice and the feedback we get is that, most companies are not looking for, an academic sort of exercise when it comes to privacy. I'm very rarely asked to write a memo, even though memo writing was a huge part of, the legal education. It's like, I want 4 bullets, tell me what it is, what the risk is, and, can we do it or not, what I need to tell the business, because I need to just be able to implement something. So being able to drill your advice down into that kind of digestible form of information really requires understanding, again, what the business is, what their priorities are, and like a practical interpretation of what those laws are. And this is a space, I really appreciate. And like I mentioned, our group sits within this larger media technology practice, and a lot of our clients are in the advertising and media space. And so while privacy impacts every group, I feel like for that space in particular, the data flows are so complicated. What they're doing is complicated, and they're within the spotlight. All of the state privacy laws specifically call out targeted advertising or sharing for cross-contextual behavioral advertising. Like that is the target of what a lot of these laws are meant to solve for. And as Mary mentioned, a few years ago, you would have gone into a company, they would say, well, we're just selling shoes. It doesn't matter. It's just ads. It's like no big deal. We don't understand why there's pressure here. But I think over time, it's become clear that the volume of data collected in connection with delivering ads, even if those ads themselves are fairly innocuous, the access to that information is where the potential harm lies, right? And that's harm to your consumers, and that's also harm to your business, because as a brand, you don't want to be the company that exposed your customers' data. You don't want to be the company that law enforcement accessed information and there was some, harm that ensued from that. You don't want to be in that position. So on all sides, I really think there's a motivation for solving these issues and maybe, cleaning up some of some privacy practices of the past. So, just leading off into maybe some tips for those who are moving into the space or thinking about this space. I'd say, read is critical. Like stay on top of everything. IAPP is a great resource. There's also a think tank called the Future of Privacy Forum. They put out a lot of great material that will keep you up to date. There are lots of, and depending on what industry you're in, there are industry organizations that are specifically focused on privacy. And there are tools like OneTrust has a tool called Data Guidance, which gives regular updates and then deep dives into the law. But figure out what tools and resources you can use. And if you're not connected with an organization, just, you can set a Google alert at the very basic and then just get information about what changes are happening so you can stay on top of it. Know the business and know the technology, figure out what's going to be most relevant for the space that you want to operate in, and make sure you know it really well. And then lastly, just network, right? Like I've talked to many people who have gone through this process of trying to transition into this space, and they do a great job of getting out. And I will say, we're sitting on this great panel of diverse women. And this is a profession that, at least in my eyes, is largely driven by women, right? Like some of my privacy heroes they're mostly women, leading a lot of these big privacy practices, largely women. And it's a very, I think, inclusive, welcoming environment. So if I have questions, I don't hesitate to reach out, even like across law firms. It's not, we're all trying to solve problems in the gray area together. And so I would encourage people to really take advantage of that collaboration and the good community, I think, that we've built up here. So with that, I'll wrap up. The one thing I'll say is maybe the thing I'm most excited for about privacy is the move towards privacy enhancing technologies. Because one thing, at least I'm seeing, is it used to be that technology outpaced the law. So the law was always chasing up to technology. It was a bill written, in the 80s being applied to 2000 technology. That doesn't always work. But now the law in some respects is outpacing the technology, and that we don't have the tools to do all of the things that the law wants us to do. Yes, we need to respond to the browser-based opt-outs, but where is all the data sitting? How are our systems set up? Or can we translate that signal? Can we make this work? And I think I think the use of privacy enhancing technologies to find a path forward for some of these challenges is really exciting. So I will leave it with that. Thanks.
Thank you, Jessica. So now, Marie, I will project your slides, okay?
Yeah, sure. So happy to be here with you. This is already an amazing community and an amazing event. So thank you for having me. My name is Marie Potel-Saville. I'm the founder of a legal innovation studio called Merry Marwig. And today, well, we've already started actually talking about people, harms and fairness, and I guess it's the perfect transition for what I'll going to talk about, which is designing privacy for humans, for the people out there, and fighting dark patterns in the hope of fostering user sovereignty online. So, as I said, we're a legal innovation studio. We do many different things, and privacy is about 1/3 of our activities. Basically, our job is to make law for humans, taking into account their needs. So that's design thinking, basically, but also their cognitive limitations, thanks to neurosciences. And we add plain language to that, and of course, a bit of legal expertise. So we all know the problem with privacy online. This is no big news to you. I agree, is probably the biggest joke on the internet, and it's been for, sadly, over a decade or even two. Whether it's 99% of privacy policies that are blindsided or 98%, it doesn't really matter because the number is way too high. What's for sure is that 100% of users have a bad experience with privacy policies online. And it even went to the point, I'm sure you've seen this great article, Luiza, by the way, thanks for sharing it a couple of days ago. So some very renowned scholars in the US actually came to the conclusion that based on all that, actually Americans can't properly consent to the use of their data First of all, because they don't have a clue, they don't understand all of these privacy policies, and of course they help us to control it. So it's not doomed to be this way, just to be really clear. And also, as a lawyer, it's always good to have a small reminder about the fact that privacy laws around the world, more or less, in particular in the US and in the EU, actually impose transparency and usability. So, of course, GDPR, especially Article 12, it's a slightly underrated article in GDPR, but it's extremely important. Concise, transparent, accessible language using clear and plain language. In the US, it's slightly different, but still, whether it's federal or state laws or the FTC decisions, they either require implicit or explicit permission, which in any event requires people to understand what's going on. And obviously, increased transparency is required for underage users, which incidentally are 1/3 of internet users in the world, so definitely not a detail. What's interesting is that these privacy laws imposing transparency and usability of legal information actually do not come in isolation. If you look at the bigger picture, around the world, there's like a legislative wave against opacity in legal information, against misleading terms, whether it's consumer law, but also competition law, and lack of user centricity. So clearly, this is part of a bigger movement. Now, based on all of that, the question we're trying to answer is how do we make privacy a reality for humans? So basically, this is where we apply legal innovation by design. We combine user centricity. So, we do user profiles, user journeys. We didn't invent any of that. It's been there for decades, obviously. We use that to restructure the information in a way that makes sense for people. Obviously, we leverage neurosciences to take into account information overload, for example, which prevents most humans from learning anything. And we use plain language while retaining the same scope and precision, and obviously UX design, service design. And as I'm sure you know, design is how it works and not how it looks, just to be really clear. So at this point, you might wonder, what do human-centric privacy documents look like? So here are a couple of examples. Basically, when I created the agency back almost 5 years ago, we started nearly with privacy. We were lucky to win a tender with the French Data Protection Authority, the CNIL. And from there, we started creating model interfaces and privacy policies to empower users to really understand and exercise their rights. We also created methodology toolkits for designers because, of course, and as Luiza very rightly said, this is a completely multidisciplinary issue. So it's not lawyers in isolation. It's not designers by themselves. It's not developers or CTO on their own. It's really about multidisciplinary collaboration so that we make privacy a reality for humans. So in each case, just to be really clear, in all of our projects, we systematically do focus groups or user interviews. In any event, there's a lot of user research, and we also co-create with the users their ideal privacy policy, for example, and of course, there's a lot of user testing. So these are just other examples. I'm not going to go through all of the examples. It would be a bit too burdensome, but just interestingly, we managed to create model interfaces for kids as young as 8 years old, explaining exactly what happens with their data. So if it's possible to explain in simple terms to kids of 8 years old, like mine, for example, then for sure there must be a plain and clear way, an empowering way to do that for adults as well. We also created, methodology toolkits. We're really honored to create a privacy saga for King, which got us a couple of innovation prizes, which of course, are not an end in itself. But I think it's really interesting that IAPP, for example, recognized this project as innovative because it's fully user-centric, and that might be a shift in the way we approach privacy. Again, privacy for people, privacy for humans. So it's online. You can scan the QR code if you want to have a look. You can take the quiz in the end to test your knowledge to see whether it was clear enough, and let me know afterwards. And for sure, we're continuously improving it. So, we're not saying this is perfect. Absolutely not. This is always work in progress, and that can be totally improved. So, of course, it's not just for kids or teens. It's about everyone. So this is another example. And it's not just privacy policies themselves. It's also, for example, the very tricky data protection addenda. I'm sure we've all struggled with them. Well, it's possible to transform what you see on the left-hand side to something a bit more digestible. It's the same for GDPR compliance programs, of course. So now, if I have maybe a couple of minutes left, Luiza, do tell me. So I might touch upon dark patterns very quickly. So it was a term coined over 10 years ago by Harry Brignall, of course, as tricks used in websites and apps to make you do things you didn't mean to. What's really important is that since then, many scholars around the world have really worked hard on defining dark patterns, on creating taxonomies, and there's all this amazing academic work. Most definitions include notions of, modifying people's architecture of choice, basically. And that's definitely manipulation, and that's not on. So, of course, that privacy-related dark patterns are clearly prohibited. There is no gray zone. I very often hear that. There is no gray zone about deception in privacy. Absolutely not. In the US, there's the FTC staff report that couldn't be clearer, to be honest, and that's clearly signaling strong enforcement. California Privacy Rights Act clearly says that consent obtained through dark patterns does not constitute consent. Again, nothing gray about all that. It's perfectly clear. And in the US, in the EU, obviously, we've got GDPR and specific guidelines in social media. So our work consisted in, many different things in our R&D lab, but basically we tried to create a usable taxonomy of dark patterns, but also their countermeasures, fair patterns. Again, I don't have time to go into all the details, but basically the idea is to move from dark to fair patterns, and fair patterns means that users are in control, humans are in control. It's user sovereignty. So we actually build on Luiza's work, namely her autonomy preserving measures, but also on the fairness by design duty proposed by the Competition and Markets Authority in the UK. So what does it look like? Very quickly, we've got 23 prototypes currently, which are being assessed by independent experts. And then, of course, they will be user tested, but it could be like neutral or protective default. It could be, the cookie banners that we were talking about at the beginning. It's a classic, but about 50% of all cookie banners are really not compliant, if not more. It could be adequate information, for example, about geolocalization.
Wrap it up. 2 minutes. Yeah.
Yeah, sure. I can actually stop here if you need me to, Luiza. That's okay.
So just
I think people got the idea, and perhaps if you want to continue the conversation, I'll be in DC for the IAPP Global Summit. I'll have a roundtable with King, and so very happy to continue the conversation over there. Thanks a lot.
Thank you so much, Marie. And now we continue with Siobhan. I will present. Can I put your presentation, Siobhan, as well?
Yes, please.
It's a dynamic presentation here. One after, it's so many interesting topics. So Siobhan, please.
Hi, everyone. So I'm Siobhan. I just need to get my mouse into the right place. So I come from a little bit of a different background than most of the really phenomenal, amazing women that we have here on the panel. So I wanted to touch on that a little bit. So I actually started, where's my mouse? I started here, meaning I was a musician, living the life, working the night job. And when that got a little too tedious for me and I decided I needed a little extra income, other than, let's say, some occasional bartending, I got into football. But not into football the way that you know it. I got into football because I started betting on it. I know it's not the most ethical way to make money, but I have to thank it for getting me into data and where I am today. Because when you start betting and you want to actually win consistently, you have to understand data and the possibilities of what you can do with data. So you learn a lot about statistics, how to model data, as well as statistical programming languages. What that led to is that once I moved countries, it got me a job at a media company where I had the privilege to be able to work through all things marketing. So obviously analytics and data related things were coming natural to me. I also got to work with business intelligence and then move into content and optimization. Obviously there's a little bit of everything there, PPC, et cetera, but it's all quite data driven. And the beauty of that is that it gave me a really solid foundation of data and marketing that I did over 10 years. As I left the company, I built out my own agency, a really small agency. We focus specifically on optimization and measurement. And the real reason for that, and it's the same with, within privacy programs, is it's a lot easier to optimize something or adjust a process if you measure the data and you understand the user's behaviors around it. So what we essentially did is we set up tracking, we did user behaviors, we tracked all the user behaviors, and then we optimized websites or user experiences based off of what we saw and what the data gave us. And this was all a lot of fun until we got to GDPR being enforced. A bunch of people started asking. All my clients who were great were like, what's going on? Are we compliant? Can we even optimize? Is what you've set up with all the tracking compliant? Is it allowed? Is it okay? I don't think they were really asking to fix it or change it. They were more asking to address and see what their risks were. But because I was the person that they were coming to with all these questions, it got me to dive into and explore privacy a lot more. And that ended up to bringing me to where I am now. Getting to play with privacy a little bit more and understanding it and educating myself, and obviously over time getting whatever certifications I needed, etc., gave me a really good grasp on what's happening. So now I get to consult companies on how to make marketing and privacy work together. A lot of it is all the stuff that most of us do, which is data mapping, customer journey mapping, and a lot of the more implementation, like technical things as to where the data can go, where it cannot go. But I've also realized that a lot of what's happening in my job is I'm acting like a translator between, let's say, legal or the DPO and marketing, because there's somehow a disconnect there. So what has happened is I have realized that we both are actually serving the same person, which a lot of people have mentioned already on the panel, but we're completely not connecting that and not making it work for us. So in the end, privacy and marketing is all about the user. It's about everyone. It's about you, me, it's all of us. Privacy is there to serve us and respect our data and make sure that we have everything, sorted. It's being protected, right? It's a fundamental right that we have. And marketing is there to try and get you to see what it is you might want to, or to give you an experience online that you would want to experience. There is scammy marketing, of course, but ultimately it is about giving you what you want to increase your user experience. So why am I mentioning this? Because we all are very clear about the fact that marketing needs privacy. We understand that we need it to gain our customers' trust. We understand that we need it to stay competitive, because if we aren't going to start showing that we are respecting people's data and telling them what we're going to be doing with it, they will go to our competitors. And essentially, it's helping us stay relevant. There is a lot more to it, but I really want to focus on the other part, which is, why does privacy need marketing? And this is where I feel really strongly, because as it's been mentioned a few times now, there's a tendency that privacy can be overwhelming. There's information overload. There is, you can't understand what you're reading. People don't know what cookies are, so how can they consent to them? So I'm not going to go into the details because we're short on time and we have covered a lot of that. But ultimately, privacy needs to be understood. It needs to be clear, and it needs to learn how to communicate better. And what better way to do that than to start looking at marketing? Meaning, it's just like you can use design to help something work better. You can use content to help something work better. And you can also use the data that you are collecting to inform what would work better. What I'm suggesting is that you work with the marketing team instead of against it, by understanding that you guys are all in the same boat and are trying to cater to the user. Because ultimately, the person is at the other end of each transaction. Now, in marketing, we have a transaction. We're getting the data and we're doing something with it. We're retargeting them. We're doing everything else. In privacy, we have that same transaction, right? Meaning, we're not actually controlling the process, but ultimately that data is being given to the company and it's being processed, and it's privacy's job to make sure that that process is going to be relatively secure. And that data is being protected, and obviously you determine various things such as retention, etc. So the user is at the end of this transaction, regardless of your privacy or marketing. But what does the user really want? Do they want what they're currently getting? Because they want us to respect their data. They want us to treat it well, but they also want to be personalized too, meaning you want to go to the website and have a personal experience. They want relevant, not creepy ads. So I'm going to ask for everyone to kind of step away from the legal a little bit and instead give the people what they want, which is more control and transparency as to how their data is being used. So as previously mentioned, a lot of this can be addressed in your consent banners and your privacy notices, how you design your privacy notices. Just-in-time notices are a really great way to do it as well. So there are various ways you can make sure that people feel like they're in control and transparency. But it does take us in privacy. It requires us to kind of step back and not to focus on the legal bit, and to start remembering that it's all about the user and not about, not about anything legal. So in closing, my key takeaway, I'm sorry I'm rushing this, but I'm aware that we're short on time, is that it's only about checking. It's not only about checking a legal box, right? It's about respecting the people who you trust and who will trust you, with their personal data. So I just want to highlight again, it's about the user. Everyone said it. Marie said it. Mary said it. Jessica said it. Everyone's mentioned. Luiza has mentioned it. So we all know it. And it doesn't matter what angle it's from. But I think it's important now to get to the point where we make it really work for the user. And to do that, we need to work with marketing. We need to work with the design team. We need to work with the content team. Because if we don't, we've lost them already. I mean, we already all know there's consent fatigue. So we already all know that privacy is something no one wants to talk about. So we need to make it easier and more accessible. So that is that for me. If you have any questions on marketing or how to make all this work for you, or how you make your data structures work for you, you can reach out to me on LinkedIn or find me on my podcast. But you can find all of it on LinkedIn, Twitter, everywhere. I'm quite active. So thank you, everyone on the panel, for being here. It's been amazing listening to all of you. Thank you for having me, and thank you for listening.
Thank you, Siobhan. Now, Kristin, please.
Yes, thank you. So hi, everyone. Yes, happy to be on the panel today, and many thanks to Luiza for the invite to join this wonderful panel. I am Kristin Johnston, and I am Associate General Counsel of AI, Privacy, and Security at Affinity. And just a quick overview about Affinity. Affinity is a leading provider of artificial intelligence that pairs customers and contact center agents based on how well they are likely to interact. And businesses around the world use our AI to boost customer and agent satisfaction, lower costs, and increase revenue by improving sales, service, and retention. And just a quick overview about my background. I started in a law firm, followed by 12 plus years to date working in legal regulatory compliance, which includes over time increased focus on privacy given the changing regulatory landscape. And I would say my curiosity turned passion for privacy probably started during undergrad at Harvard when Facebook launched on campus in 2004. And I know I'm dating myself here. I thought the platform was fascinating, but I was also mindful about what information I chose to disclose on there, in part because of the controversy around Face Smash in 2003, where campus house Facebooks, and I think that's what they were called back then, campus house Facebooks, they were accessed, and users of Face Smash could vote hot or not on student ID photos. And I have no idea if my photo was included in that thing, but I hope not, because that photo was terrible. Fast forward to 2023, and my curiosity in data collection and data use has grown over time, along with my passion for ethical and compliant use of personal data. And this particular item, the ethical and compliant use of data, ties directly into my topic for today, which is figuring out the best ways to champion privacy within your enterprise, within your organization. It's not a one-size-fits-all type of an effort. What works for one company may not work for another company. That said, I believe it's so critical that we all carry our privacy pom-poms and champion and cheerlead privacy as much as possible in our roles. And I believe these 5 tips in particular, these 5 tips in particular likely work across the board. So I'm going to get through them as quickly as possible. So let's jump into it. The first tip is make privacy relatable. For business buy-in, you should encourage teams or team members to think about a product or a service from a consumer lens perspective. In essence, they should put their consumer hat on. What do they think about when deciding whether or not to share data with the company? What concerns do your team members have? How does privacy impact their decision on whether or not to use a service or a product? And this is very helpful when thinking about privacy by design best practices, building privacy into the data lifecycle of a product, and ultimately really thinking about how do you feel, or how would you feel if your data was used in this way, in this product or in this service? And the second tip I wanted to stress is the way you speak about privacy is critical. It matters. It's not a cost center. The privacy team is not a cost center within the company. Privacy is instead a revenue generator and a revenue protector. And it's easy to see privacy as a cost center, like a compliance check the box exercise. And the better way to see it and communicate it is tying privacy to your company's revenue. Privacy is, in fact, a business issue rather than just a regulatory matter. And specifically, when you think about privacy by design, you're pretty much embedding and baking privacy into your product and your service. And this allows the business to leverage privacy as a competitive differentiator in the marketplace, which supports revenue growth, and also mitigate legal and data risks, which helps protect revenue. Privacy by design supports revenue growth because it inherently supports business interest and innovation. So I strongly recommend using those points whenever you're talking about the value, the importance of privacy. The third tip I'll quickly mention, tone at the top is critical. It's so helpful when senior leaders stress the importance of privacy. For example, if it's featured in your company values or in your core value statements, if it's mentioned regularly during all staff meetings, or perhaps you have an intranet site and you have a privacy blog or a privacy corner, something like that, you can leverage that tone at the top about the importance of privacy in your day-to-day work. Fourth tip I'll mention is partner with the business and get invited to the right meetings. Make sure you're aware of your key stakeholders throughout the business when thinking about privacy compliance and privacy by design, and partner with them as they work on accomplishing their business goals. And that especially means learning, being curious, listening to the business, listening very closely, listening to their goals and their needs. Genuine collaboration and partnership is a two-way street. And I found that you're far more likely to have people listen to you as you're talking about privacy if they believe you're also listening closely to them and taking their points to heart. Also, another key thing I'll throw out there, and I think this was also mentioned during today's panel, is, of course, be involved at the beginning of a project, of an initiative, so you can be mindful about privacy by design best practices. And final tip is grow your internal privacy champion network at your company. help build out a privacy culture throughout the company by leveraging privacy champions embedded across the enterprise. A privacy champion network provides a direct funnel into the business across various teams, which is very helpful for sharing certain updates and pretty much having a privacy communication hotline across the company. So that was a quick run through of 5 tips. Just a quick recap: make privacy relatable. That's number 1. 2, be mindful about how you speak about privacy. 3, tone at the top is critical. 4, you must partner with the business. And 5, privacy champions are the best. So that's it. And I'll turn it back over to Luiza with, I think, 1 minute remaining.
Thank you so much. So that's it. We had our 6 small sessions. So I want to really, everybody here is busy. I know the audience is mainly of privacy professionals. So as we just said, there's a lot to read and a lot to do. So we don't have forever. So I hope you like this very dynamic format. If you want to get informed about next Women Advancing Privacy sessions, so please sign up to the Privacy Whisperer. I have this session, this area for events, so you can learn there. And if you have idea, if you like this format, if you don't like, please let me know. Write to me. And I think everyone here is on LinkedIn. I think everyone, if you want to get in touch with them and follow questions, please, all of us, you can follow us, send messages, and we can continue the conversation, because the idea was to be dynamic and quick and very watch again this session. It's a lot of information. It's precious what you just heard. It's I was learning a lot here. And that's it. Let's continue the conversation on LinkedIn and on anywhere, email outside of this panel. And yeah, and see you in the next Women Advancing Privacy events. So bye-bye, everyone. And thank you for joining us in this panel.